Lights, action.
Alright, so there's a term. How many people in this room know what jurisprudence is?
You? Yeah.
Okay, jurisprudence is the philosophy of law. That's kind of what this talk is about. And the concept of intent is relevant to so many areas of law. But first I want to ask, like, how would you define law?
Law, common law,
Yeah,
what
common
we've
law?
established over 1,000 years,
Yeah. What is the function of law?
to keep us all under the thumb.
No.
Justice.
Justice. Okay.
Relegate. Not relegate.
Regulation.
Yeah, the
Regulation. Sure.
Regulation.
So one of the most, I would say, influential documents about law is William Blackstone's Commentaries on the Laws of England. And this was from, 1765, 1769. It's very old. And the way that the law is separated here is persons, things, and public wrongs and private wrongs. And I would say these are probably the two most central dichotomies in law. The difference between persons and things, and the difference between public and private wrongs. So if I were to ask, what is the difference between a public wrong and a private wrong? How would you answer that?
Private wrong is, say, a civil matter where I owe you $1,000, and a public wrong is if I get caught speeding or something like that.
Right, so it's between individuals
Yeah.
versus between an individual or a group and the government. Yeah, and I guess there's a similar difference in, I mean, this one is, I think, being challenged now, but for most of human society, this one is a bit harder to tell apart than this one. So I have some more questions just to sort of give an idea about the topic. What legal differences are there between people and property? How can you point to, actually some idea? So
Property doesn't have rights, but people have.
property does have rights.
Oh, do they?
Property does have rights. But property doesn't have responsibilities. In other words, it doesn't have a capacity for intent. And so, what should the processes and outcomes of disagreements, when should they become public? If I have a disagreement in a one-on-one matter, should the result of that be exposed to other people? When is harming others a criminal act?
Only if there's a public interest.
If it's in the public interest. Now, how do I determine if it's in the public interest? In practice, how is that determined?
Good to the benefit or wrong?
Yeah, its outcome will affect everyone eventually.
Well, there are lots of cases now where decisions are made and the outcome would affect other people, but it's still private. Why is that? Well, the last question, when should legislators or courts make moral judgments? So how laws are made, you either make them before you go to court or you make them during court. So what degree of moral decisions should be happening before the fact or during the fact? And this is a difficult thing to say. How much discretion should a judge have in deciding whether something is moral or not? Should they have to follow a textbook which says this is moral, this is not? Or can they make up their own mind with some topics, or maybe with all topics?
Just one quick question. When you said property doesn't have responsibilities, if the roof falls on us today, don't we sue the property insurance?
Well, the property insurance is a person, a legal person. The roof isn't. So, here you go. These all depend on intent. So, intent is central, I would say, to how all of law is administered. And it might not be obvious why malicious intent is a termination for criminal acts, for example, but I'll go in that in more detail. In de facto and de jure justice in most cases, intent is what decides whether it goes to civil court or to criminal court, at least at some level. But you can't know what a person's intent is. It's like reading their mind. You can know what a person does. You can never know what they intend to do. If you have a confession, you still cannot be certain what the person intended to do. It doesn't matter what ends of the earth you go to. There's always an element of uncertainty, and I think, all of justice is underpinned on that uncertainty. So, here's another few questions. Is it a crime or a civil wrong? Fraud. Do I go to criminal court for fraud?
Yes.
Yeah.
Fraud.
Yes?
Yeah.
Okay, what about sexual harassment? Criminal or civil?
Civil.
Civil? What about speeding?
Criminal.
Civil.
Yeah, criminal, I know, I've been...
Okay, mixed answers. Okay, what about disorderly conduct?
Criminal.
Civil?
Criminal?
Depends.
Civil.
Civil?
I think.
It depends.
Criminal.
If no one got hurt, it's civil, surely.
Alright, fraud, it depends. You can go to both. Sexual harassment is civil.
Mhm.
Speeding depends on the state. In New South Wales, you get penalties, but you can't go to jail for it. It's actually separate. And disorderly conduct is yes. Now,
Oh, that's new 2011. Okay.
yeah. Now this is
Sorry, we didn't understand what disorderly conduct.
disorderly conduct is like a person wandering
No,
around on the
is it
street.
civil?
Which one is it?
It's oh I put yes. Sorry, it's criminal.
Right.
Yes.
Really?
Is that like offensive behaviour, is it?
That's the statute. It's under criminal code.
Rather than
So
orderly.
yes. Now, what about the United States? This is a different question. Not civil or criminal, but this time, is it inherently immoral to drive recklessly? Am I committing a moral sin by driving recklessly, by going over the speed limit, by swerving? It's considered immoral by the U.S. courts.
Really?
Yes. I'll explain in more detail what I mean by that. But okay, so driving recklessly, we're saying no.
Not there.
Okay, what about driving while intoxicated? Is that inherently an immoral activity?
Yeah.
Yeah. Okay.
Knowing.
So you could be driving recklessly and intoxicated. That would be immoral. But if you weren't intoxicated, you're just speeding.
If you
Okay.
were, if you were
Don't
trying
two
to,
wrongs make a right?
No, if somebody was delivering a baby, you had to go to the ER.
Okay. What about causing pollution? So I have a very specific quote here from case law. So discharging iron particles and an oily substance into a river. Do we think that's inherently immoral? That I know I'm going to poison people.
Intent.
Okay. Yeah. Now,
Immoral always has something to do with marriage. Get rid of marriage and there's no immorality.
oh, that would be
Religion.
nice.
It's
Yeah,
all
if all
religion.
legal matters were about marriage, then we'd go back to the 1800s probably. So, and the final one, okay, well, I think this one is pretty obvious, right? Well, no. No.
Depends on.
Rape. Is rape immoral? Not according to the US.
We can't see it.
It's impossible for a woman to rape a man.
So it's criminal, but it's not inherently immoral. It's only immoral as a matter of cause. And this was an old precedent. It's not used much, but it's also never been challenged. So yeah, I've got some court cases here, and so in the United States, driving recklessly is inherently immoral. If you go over by if you're driving at 35 kilometers an hour, and this is 1930. So there's not as many cars. 35 kilometers an hour, that's inherently immoral. But killing two people because you drove on the wrong side of the road and you speeded, that's not.
So stop it with the penalty though.
The penalties. So when I say inherently immoral, there's actually a legal term for that, which I'm going to go about in the next slides. And the distinction in that, essentially that legal test, is what decides whether you get a jury. It decides your sentencing. It decides basically a lot of preferential treatments in court, whether you get whether you can get bail. There's a lot of factors that go into this. So yeah, driving while intoxicated, well, depends on which court you're getting heard at, really. Causing pollution was no, not inherently immoral to poison people, to dump waste in a river. And interestingly, the trend has gone further in that direction, where now pollution is no longer mostly criminal. It still has a criminal code in the US, but it's mostly under civil courts now. Mostly it's through civil penalties, and I don't think civil penalties have been very effective at getting environment protection. So the short answer is it depends where you're getting heard, depends on whether the judges eat in today, whether they're feeling happy or sad. It depends on the weather. It depends on a lot of things, really.
Really?
So
Some courts charge more to enter into the court, so the lawyers prefer those ones.
Oh yeah, sure. So there are a few differences between civil and criminal law in Australia, in the United States, and elsewhere. But this slide is like mostly for Australia. So the standard of proof is different. So if you want to prosecute someone, what you have to prove is different. So in civil court, I have to prove balance of probabilities. I have to say there's at least 50% chance that you did the thing that I think is bad. Whereas in criminal law, there's no reasonable doubt. I have to convince the judge, and sometimes I convince the jury, that there's not a single person that voted against it, that everyone thought it was bad. Civil penalties are generally only financial, and there are things you can do other than a financial penalty or going to prison. For example, you can make a company be forced to do something, but in generally speaking, civil penalties are only financial, and you have to have intent. In civil courts, intent is a non-factor. You don't have to prove the person intended to harm you to seek damages. But in criminal courts, sometimes you do, sometimes you don't. And often that is a central fact of the case. So what's a joint penalty submission? Does anyone know what that term means?
Which?
A joint penalty submission. No? Okay. So what about plea bargain? Do you know what a plea bargain is?
Yeah.
You're Yeah. So there's a very interesting story about joint penalty submissions, which are actually it's another term for plea bargains in Australia, which I'll be talking about as well. And in theory, that there is some Australian legislative material that suggests that criminal law is retributive in nature and civil is meant to be preventative. And in practice, due to the protections granted by criminal law, it is easier to prosecute welfare fraud than murder. So this is Yana v. Eaton. So this is a case where there was an Aboriginal tribe and they were hunting crocodiles as part of their tradition. And because of that, there was a law that said that they couldn't do that. So it went to the High Court, and they were trying to figure out whether the crocodiles were entitled to be hunted, basically. And they decided that the Aborigines were okay with hunting it. But the concept of property is pretty ambiguous. It's just a bucket. It's just a bucket where you put stuff in. And legal persons are the same principle. You put stuff in and you take stuff out. You've got rights and responsibilities. And you can't have responsibility without a concept of intent. Because if you don't follow the responsibility, you have to force someone to intend to change it. There's no way to have that concept otherwise. But is intent a right? Because that's the only thing that separates, in practice, the people and the things. So is it a right that I can be punished by forcing me to change my intent? Well, I don't know. Why do animals not have intent? Probably because there's no lingua franca, honestly. But do we make an effort to find a lingua franca with animals? Not really. Now, lady justice does not do R&R. What do I mean by this? There's rights and there's responsibilities. Let's say there are two buckets, and they're weighing the scales of justice. And it turns out some people have a lot more rights than responsibilities, and some people have more responsibilities. And there's no balancing of these. I would say this is the central concept of justice, as it should be, that rights and responsibilities should be balanced across all individuals in society. But this is not how law is enacted, because basically you have a lot of discretionary power, and it's also very hard to go to court because, well, at least in Australia for most things, loser pays the winner's fees. And that means you can basically, it's a huge chilling effect. Why would you go if you can basically lose your whole life over something? So there are a few other dichotomies you could say, and then I don't think they have the best names, but public law versus private law is a similar kind of principle. It's whether the case is in relation to government. Civil law and common law is whether you rely on statutes designed by legislators, whether you rely on precedent decided by judges for your main source of law. And there's a bit back and forth in different countries where they rely on one more than the other. Most of them it's a mix of both, even though they say, oh, you know, this is a common law country, but in practice there's usually a mix of both. Positive law and natural law it's the idea that, you know, either laws are obtained by us in society because we democratically decide on them, versus we are naturally entitled to those rights. And They just need to be upheld properly, which is a very similar distinction to statute versus precedent, because in precedent, there's no democracy. The judge decides. In statutes, there's not necessarily a democracy, but there's a potential for a democracy in statute law because people can actually vote on it. And I don't think voting in a jury is a good way to represent civil rights. And more fundamental than this is the dichotomy of populism and elitism. So when I make a law, is it a group of people, a large group of people making the law, or is it a small group of people, or one person making the law? You can't choose any other option. It's one of those two. And how do you represent democracy in that system? And I mean, fundamentally, even outside of that, if you do have a judge, why make the judge one person? Why not make the judge all of society? Why do courts operate on that one person system? And as far as public law and private law, public law is, I would say, going out of phase. There are still certainly cases, but because of forced arbitration clauses, class action waivers, and discretionary financialized penalties, generally speaking, precedent isn't made anymore. It's decided by the people with the money, the defendants. And having forced arbitration greatly favors the employer over the employee. So what forced arbitration is if I have a disagreement with someone and I signed a forced arbitration clause, I can't go to court with them over it. I have to go through arbitration with them. And arbitration is civil. So even if I have a criminal issue with them, I might have to go through civil court first. It's a great get out of jail free. Literally, you get out of jail because you can't go to jail in civil courts.
Can you please define the difference between civil and common?
So civil law is law that relies on statutes, and common law relies on precedent. But they usually rely on both, but that's the emphasis.
You've got the criminal law, statute law too.
Sorry?
A lot of criminal law is statute law.
That's correct. These are different dichotomies. They're separate from that distinction.
Criminal law can be statute law or case law.
That's right. So civil law and common law is a different distinction to civil and criminal law. So in this case, civil law can mean two different things. Okay? So Southland Court versus Keating and AT&T Mobility versus G'MIC, these are probably two of the most widely condemned Supreme Court cases in all of history because they give enormous power to corporations. I can make you sign a term, and once you sign this, you can never prosecute me, except you have to go through my game. You have to play my playing field, and my playing field says you never get to set precedent, no matter how badly I treat you. And I would say, as far as the elitism versus populism is, I've never heard of a court which actually decides cases based on a country's vote. That would be a bit extreme, I think. But the idea that a judge is always one person, that at most you might get 9 judges hearing on a full hearing, and I just don't think a small group of people. It doesn't make sense to always do that throughout human society. I'm not saying that a large group is better, but you've got 2 options. Why do you stick with one all the time when, in a lot of the time, it doesn't work?
What about juries?
What about juries? Well, I have some stuff to say about juries. But first, I want to mention this joint penalty submission. So, yeah, you're at court, and I'm looking at an interrogation glass, and I'm deciding whether I say with the police, I say, yeah, I did it, or I go to court and I try to convince them not. And let's say I knew I didn't do it, but I don't want to go to court. I don't want to have to humiliate myself. I just want to accept it and get along with my sentence, I guess, because I'll probably get it shorter. Now, the interesting thing is, you can do joint penalty submissions in civil court too. But is it the same principle? Joint penalty submission is a term for civil court. Plea bargain is a term for criminal court, but it's the same thing. Now, the thing in Australia that's interesting is there was Barbera versus the Queen, and this was a huge drug cartel, and Barbera and Zarili, they're the 2 heads of the cartel, and one of them's getting sentenced for life, one of them's getting sentenced a long time, and they've got a choice, and they sign a plea bargain, and the plea bargain said that they'll go for something like 27 years. Then the judge looked at it and said, no, you're going for 30. They didn't listen to the prosecutor's advice on the sentencing. So, they agreed to the plea deal, and then they got a bad deal out of it, that they didn't even get the honest deal. So it was ruled in the High Court that this is okay, that judges don't have to listen to the prosecutor, that they can take it as advice, but they don't have to, that there's an idea that you have to separate the judge from the prosecutor, that they should be independent.
Then why have it in the first place? The plea bargain.
Well, plea bargains, it's a... So in civil courts, it was an extremely common occurrence until May 2015, when it got outlawed. Then in December 2015, they brought it back. And now you can still do joint penalty submissions in civil court, which is a huge get out of jail free card. It's basically, I'm a big corporation selling cars, and I want to be compliant with this policy. They're saying I'm not. I don't really want to be, but I just talk to them. Oh, I can pay them $1 million. My annual income is $2 billion. I don't care. I pay it to them. I'm fine. So the distinction that's essential in all of these is malum in se and malum prohibitum. And this is what the core of my talk is about. So malum in se crimes are illegal because it's immoral. So murdering someone is immoral no matter what court I go to. That malum prohibitum crimes are immoral because it's illegal. So a parking violation is the most simple example. It's not fundamentally immoral to get a parking ticket, to park too long at a spot. But it becomes immoral because it's banned. So what's the difference between banned and wrong? How do you interpret that in society? Now, this is a very old concept. In 1496, there was the divine right of kings. If you went to court and you were convicted for murder, the king couldn't pardon you. But if you were convicted for something less severe, like, I don't know, some courts, they said stealing was okay. So the king was able to pardon you. But the idea is that some crimes go beyond even the divine right of the king, that it's the power of God, that I can't pardon. That was how it goes anyway. But what does this mean in practice? Isn't it good enough for me to just know something is against the law, even if I disagree with it? Why does this distinction matter? Well, it goes by a lot of names. How many of these terms do you recognize?
You see cards if you can't see them.
The red ones are hard to read.
So, malum in se, intent to harm, malice aforethought, malice in fact, mens rea, moral turpitude, and I don't know how to say the last. Yeah. Versus negligence, civil wrongs, tort, breach of contract, breach of fiduciary trust.
They can't see.
That's what I'm
That's
reading
why
it
she's
out.
reading it out.
Yeah. So breach of fiduciary trust, malum prohibitum, which I mentioned before, malum prohibita, because people like Latin so much they change the spellings of the words. Malice in law, and another word in Latin. So these are all malum in se versus malum prohibitum divides an enormous section of how law is conducted, and in principle, de facto, civil law acts as malum prohibitum, even though the term isn't used in that context. That's why I group them together, because you don't require a determination of intent to prosecute these crimes. And it's the same with malum prohibitum in criminal courts. And this term, malum prohibitum, malum se, is not used in all courts, it's not used in all cases, but the idea goes by so many names, and it's such a universal concept. And yeah, fiduciary trust is a big topic, but it's a part of civil law. So now, I think this distinction is absurd, and we should get rid of it. So I have a thought experiment for you. So I'm in a hypothetical world, and I want to get an abortion, and abortion is illegal. So I go to a doctor and I beg them for an abortion, and they say yes, and I get the abortion. Then someone finds out. I go to court. The doctor's in trouble because they didn't decide at the time whether it was an intentional crime to harm society to give this abortion. So what they have to do, they have to figure out if the doctor intended to harm people by giving the abortion or not. If they thought it was immoral. So if the doctor thought it was immoral to prevent the abortion because society says it's immoral, then they get punished more. that's how it would actually work, at least hypothetically.
But technically, without the doctor, there's no abortion, so he's guilty because that's the law. Black and white. I see
Sure.
it.
Sure. So the final argument that I want to make is the homunculus argument, and this isn't mine. It's from a person called Robert Sapolsky in this book Behave, which is the best book on neuroscience I've ever read. And so what is the homunculus argument? I'm a human and I make decisions, and you know, I could imagine for a second that there's a little person inside my head, like in Inside Out, and they're at a control panel. Maybe it's a group of little, you know, cartoony fellas, and they need to make the decisions, and sometimes the control panel doesn't always work. So you know, one night, and I'm out and I'm drunk, I decide to go drink driving, and these people in the control panel, they're trying to keep the car straight, but it keeps swerving. Now, is it the control panel that's faulty, that they can't control how my hands are moving around the steering wheel, or is it the little people who are messed up, that they're intentionally choosing to wheel the car out and swerve it? So this is the difference between Mellimancy and Melon-prohibited crimes, and this is a term in philosophy. This term is mitigated free will, and the foundation of so much law depends on this concept, which is actually completely fictitious. So in the context of drink driving and adolescent maturity from brain scans, it doesn't exist. There's no difference between a person intentionally choosing to have a seizure versus a person unintentionally choosing to have a seizure. It's just bioinformatics. It's just chemistry. It just happens. There is no molecule in the brain which points to intent. There is no homunculus. This homunculus doesn't exist. Now, you could believe in a homunculus like this. You wouldn't call it a homunculus, but you could call it something else. You could believe in it with religion. You could believe in it with superstition. You could believe in it with a lot of theories. But scientifically speaking, the homunculus does not exist. Now, the thing that's really shocking is that this homunculus is the basis for all of modern law that revolves around this Mellimancy, Melon-prohibited distinction. Should we sentence people to jail for having a seizure that knocks someone over? Should we sentence them for crashing a car when they were drunk? Or should we just give them scot-free because they made a little lapse of judgment? Well, what I think is the law shouldn't be designed retributively, that the people should be given a chance to rehabilitate. And the nature of law is you only dish out penalties. In civil law, most of the time, the penalties go to the government. They don't go to the plaintiffs. In most of the time, in criminal law, you don't get anything back. They just go to jail. They just have their life ruined. And that doesn't fix things. Pushing problems away into a closet means lots of people live in closets. And that's a really sad society to live in, when especially the basis for that, the legal basis, has no scientific merit whatsoever. So that's my talk.
Questions of clarification. I actually have one to do with the last slide, when you sort of said perhaps you shouldn't go to jail for a lapse of judgment or something like that. But all the prehistory of driving for the last 100 years, if you drink or speed and you kill someone, you go to jail. That actually prevents you, I believe, from drinking or speeding. So the lapse of judgment is not a get
So
out
what's
of...
the clarification?
What are you clarifying?
Yeah, what are you clarifying?
I'm trying to say that your argument that you shouldn't go to jail for a lapse of judgment, I think would open it all up, because we don't drink and drive because of the 100 years of history showing that you go to jail.
Can you rephrase? I'd rephrase that as a clarificatory
Yeah,
question.
well, what's the question you have for
Okay,
me?
the question. Okay, then the question is: do you believe that the 100 years of history prevents us from drink driving?
So I'm going to be honest. That doesn't sound like a point of clarification.
Okay, right. I'll step back.
So I mean, the idea that I'm trying to say is I don't think retributive justice is effective at a large scale. I think it should be used sometimes, but right now, retributive justice is used 99.99% of the time.
Yeah.
When I think it should be used maybe 5% of the time. It's a big difference. And I haven't seen a human society which goes less than 90% along that spectrum.
Well, we don't know
Yeah.
how many.
So let's do questions. So people raise your hands.
Geoffrey has a question.
Okay,
Yeah, Geoffrey has a
clarificatory question. Do we mean rights? People have rights, but it's not a right of property, but a right. The property does not have rights, but I have a right to property. A right of property is different from a right of a person. Meaning, the right of property means the right of my ownership of property, and to demand that society respect that right, my right of that property. Just a
So
clarification.
is the right to property something a person has or something the object has? Is that what you're asking?
Yes.
Yes. Well, I've read material which suggests both ways. I'm not sure how meaningful the distinction is on some level. I guess I don't know what to say to that.
Another question. I was going to say the gentleman at the back, that's Alex.
Ha 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 ha. Yes, it is me. Would you say that when you talk about intent, what the distinction you're making is between something that someone made happen and something that they didn't make happen?
Sorry?
Well, when you talk about intent or free will or that kind of thing.
Intent is the difference between murder and manslaughter.
Yeah, but I mean, to define it in nice and precisely.
Sure.
I mean, what you seem to be saying is you're denying that distinction should be even considered, right?
In legal courts and in general social opinion,
which,
because
and I'm trying to point out that I'm wondering whether the distinction I'm making is the same distinction, right? Which is between things I made happen and things I didn't make happen.
well, can you find the cause and effect?
No, but
So you did something, it caused something else, then something happened. Can you figure out how your actions caused that thing to happen? Is it concrete? Is that cause and effect concrete?
But when I actually decide to do something, that's different from something happening which I didn't decide to do.
Well, that's mitigated free will. So what I'm saying is that Mellum and Semper Prohibitum is mitigated free will in the legal system. And I think that's wrong. I think that we shouldn't adopt that kind of philosophical attitude when there's no scientific merit. And plus that all the people it harms. Okay, next question.
I think that I'm hearing you say that people shouldn't have consequences, and is that what you're saying?
No, I think people should have consequences. I just think people should be given an opportunity to still have a life if they make a few mistakes. And whether that mistake was intentional or not shouldn't really matter that much to the court. But fixing the mistake doesn't require knowing what the intent was in a lot of the time.
Well, just as a follow-up question, wouldn't you say that would lead to more crime?
What would lead to more crime?
The fact that there's less consequences because we're so compassionate around humans.
Well, I'm not saying that people should go to court, get sentenced for murder, and go off scot-free. There's going to be some restrictions, even if they are innocent. That there are going to be restrictions about how to manage a justice system, which can never be certain, because you can never be certain of intent. And there are a huge amount, I didn't put this in my presentation, but there are a huge amount of wrongful persecutions. There are lots of people that get exonerated for crimes, and you can't exonerate someone who had a death penalty. And that's happened a lot in the United States, and I think it might happen in other countries too. So, sentencing someone to life in prison completely changes who they are as a person. And I would say for the worse. And that's retributive in nature, that you are hurting the person by punishing them rather than helping them. And I don't think human society is very good at helping people recover from what others consider immoral. That you actually have to sit down with them and talk with them and understand, and that can be really hard if there's something really toxic.
We've got time for
Have you
Okay,
like
well, thank you.
chance
Is that
to
two
study
last
that?
questions, Phil?
Oh, I just think, what about a psychopath?
Three.
Genetically, they're a psychopath because of their
Psychopathy
genetic makeup.
is the genetic basis of psychopathy is up for debate. It's a matter of degree. It's not a simple binary thing.
Oh, really? Well, I mean, what?
I would have to make a presentation on that. That's
Yeah.
a complicated question to answer.
Okay, we'll move on.
Yeah.
Second last question, and then we'll go to Craig.
Okay. Doesn't usually the justice system favors big corporation or the rich? The recent case within Rio Tinto versus the Aboriginal one, where Rio Tinto blast out their sacred site and they got a little fine. It's usually cases like that favors the property class.
Well, I mean, the penalty of going to court and paying the winner's fees is enough of a deterrent to prevent most meaningful cases, in my opinion, on its own. And that happens in civil court and in criminal court. But it happens, I would say, maybe a little bit more in civil court because the penalties are only financial. And I guess it's a matter of common practice.
To big corporation is nothing. It's just chicken feed. Rio Tinto just play.
There's a big human rights argument, in my opinion, that civil criminal distinction is a class distinction. That high class crimes go to civil court. Now, this isn't true for all crimes. There's a lot of fraud that goes criminal court. But I think the general pattern is rich people go to civil court more.
Okay. Last question from Craig, and then we'll...
Interesting about repeat offenders. How they get off and how they keep on doing the same old thing, murder, rape, the whole thing.
Recidivism is a central issue.
But anyway, that's a big issue for me and for the Western world. But in Europe now, what's going on in Europe? Or what's going on there? We'll talk about
what's
that
going on in Europe.
The mass raping going on, and they're getting let off. Afghans are getting let off for raping people because it's part of their culture. Oh, yes, it is. The other thing is,
I can't comment on it. I can't comment on it.
The other thing is I want to ask about is premeditated crimes.
Okay.
Now, if a person's laid out in writing what he wanted to do,
you can prove some of their intent if there is evidence of premeditation.
They planned it out, what they want to do, and they execute it. It's premeditated, and they're going to be surely dealt with accordingly.
I mean, yeah, evidence of premeditation is very strong evidence, but it can also be faked, and premeditation does not explain why you did something. It can explain how you did something, but not why. Well, it could be the difference between 10 years and 40 years. That's a big difference. That's someone's life.
Then you should go to jail. You should pay for that.
For how much? For how long?
Let's stop now for five or so minutes.
Okay.
Pertaining to that jail part, have you by any chance looked at what they do in Norway and Sweden regarding jail?
That's why I want to live there.
It's very, very interesting, really. They seem to know what to do. The rest of us just seem not to.
And I would like to live there.
What is it?
Okay, we'll reconvene in 5 minutes.
Thank you.